I drew to the attention of the Prime Minister, and he has looked at it and left it to me as the Attorney General. He made a direction in Cabinet, I forget the exact date, but it was after my return, that the matter should be placed, that is to say, the procurement legislation and the issue of its proclamation should be sent to me for advice. So I have been looking at it with a view to advise in Parliament. And in particular, having received the response of the judiciary, I thought it appropriate to bring it to the attention of the people of Trinidad and Tobago, as I did today, as a result of what I think are very serious concerns raised by the judiciary. But let me emphasize, because I think this is very important, that what the Chief Justice has shared with me in a written document, a 29-page document, which is entitled Commentary. If I just read the title of it, it came under cover of his letter. It's comments by the judiciary in its administrative capacity. And I just want to read, to be fair to the judiciary, into the record today what the Chief Justice said to me in his letter of the 25th of May. He said, "For obvious reasons, we have refrained from commenting on the policy underlying the legislation or the legality of its provisions. Our comments are therefore made in an administrative capacity and are not intended to proffer any legal opinion or advice. That, however, inevitably involves flagging areas of concern based on our understanding of the legislation in its current form." And in the comments, the 29-page document, the introductory paragraph says, "The judiciary in its administrative capacity has reviewed the Public Procurement and Disposal of Public Property Act No. 1 of 2015 as amended, as well as the regulations issued by the Minister of Finance. The judiciary has identified critical issues relative to the operationalization of the legislation in its current form." So today what I did is I highlighted aspects of the judiciary's comments. And the aspects of the judiciary's comments which I highlighted in the statement which I have shared with you, and the page numbers may differ from what I read from, because I tend to put things into very large font so that I can read clearly. What you may have, therefore, may have a different pagination. But you will see that I make the comment that the remarks of the judiciary, one of our co-equal arms of government, are traffic stopping. And by that I mean that they are arresting, they have given us, the Cabinet, cause for pause. The highlights that I outlined today to the House, cautions have been raised in respect of the legislation on insufficient attention to separation of powers, the wide authority of the Office of Procurement Regulation, insufficient assurance of due process, that the activities of this legislation, once proclaimed in its present form, can halt public bodies' procurement activity. It went on to say, and this I will read in some detail because it's very important, the potential for a great increase in public law litigation. This is what the judiciary said in its correspondence with me. The operationalization of the Act will lead to a plethora of disputes of public law, including judicial review and of commercial disputes. The judiciary anticipates and must prepare for an increase in said matters. The Judicial Review Act enables matters to be taken to the Privy Council as of right. The decision-making of the OPR is conceivably subject to judicial review at every step. It is fairly obvious to the judiciary that the subject of this legislation will require adjudication without any delay, and possibly a dedicated and resourced commercial court in the civil division. Without this, the functioning of the nation's public bodies may be so hindered as to affect the operations of the state. It went on under the headline, under the rubric, reversion to unmanageable workload. The judiciary went on to identify that over the last 20 years, they've worked very hard to reorganize the work of the judiciary. A good example, for instance, is to take traffic ticket cases off the roster of judges. You now get a ticket, you pay your fine, and the judges no longer have to deal with that. And the point that the judiciary is making in its commentary to me is that after 25 years of seeking to handle its workload by removing from its responsibility matters which it should not have had to undertake, the judiciary is finally beginning to be able to implement systems to manage its caseload. And then they say this: the expected workload due to the expected adjudication and provision of services to all public bodies arising from this Act, the Public Procurement Act, will negative these gains and improvements. This means that the judiciary will require far more resources. Without this, the delays in procurement-related matters, fighting for the same sort of resources as the rest of the court's caseload, can conceivably bring the public operations of the state to a dead halt. They go on to pay cognition to the fact that they have no doubt that the OPR has been working very hard at trying to get public bodies and agencies ready for the proclamation of the Act. But they say that it is the view of the judiciary that the effect of the legislation on the processes and operations of the judiciary has not yet been truly understood, and that the level of bureaucracy, record-keeping, paperwork, as well as the staff needed to ensure its proper adjudication and application are not yet being properly assessed. The policy requiring staff to undertake this work is unrealistic. There must be recognition of the need for in-house attorneys to handle the drafting of contracts. The responsibility placed on the procurement officer and the accounting officer is immense, and to require them to address it without sound legal support at risk of grave penalties unwise. They go on to say that proclamation without everyone being ready is a recipe for disaster. And they caution that the implementation of this legislation must be planned for and resourced, and at the very least, organizational re-engineering of some kind will be necessary. They make the point in the comments that they provided me with, they being the judiciary, that they recognize that this is an act that was passed by a three-quarters majority. Therefore, it is constitutional, and they make no opinion. They offer no opinion on the legality of the act, and I want to emphasize that, because I wouldn't want it to be represented that I am suggesting that the judiciary is in any way allowing itself to make and pass opinion on the legality of the act. That has not been challenged. The emphasis is that the country is not ready for the proclamation of this act. So today, I said to the Parliament in the House of Representatives today, as Attorney General and in full consultation with the Minister of Finance, who is the minister charged with responsibility under this legislation, it is my intention to reach out to all relevant stakeholders for a meaningful and candid consultation on the practicalities necessary for the full proclamation of this legislation in the shortest possible time, at which consultation we will share the commentary by the judiciary in its administrative capacity and invite all stakeholders to join with this government in the practical full proclamation of the Act. And I said to the Speaker and to members of the House today as I end that I wish to emphasize, and I do here now today before you, that the government of Trinidad and Tobago, led by the Honourable Prime Minister, Dr. Keith Rowley, remains committed to the full proclamation of the Act and will continue to work assiduously and responsibly towards that goal in the shortest possible time. The Prime Minister has been driving us in Cabinet to get this legislation ready. He has directed me to get appropriate consultations going. I've done that with the judiciary. I've done that with the Office of Public Procurement. I pause to remark that in the letter to me of the Office of the Public Regulator, which was dated the 13th of April, this is what he said, and I found it particularly significant what he said on the 13th of April after I had read the comments of the judiciary of the 25th of May, which I received on the 27th. The procurement regulator said, having provided us with a sheath of documents, responses collated thus far reveal that some public bodies have commenced the process of getting ready for compliance with the Act. However, there is significant work to be undertaken to establish the required system and processes. So even the procurement regulator has expressed his concerns about the fact there is much more work to be undertaken. And having read what the judiciary has had to say, I have advised the Prime Minister and the House today that we need more time in order to consult and to ensure that the country is ready for proclamation. So I thought I would call this media conference today to explain before you what I said in the Parliament today and to invite any questions from you in that regard. I now invite questions. I'm going to ask for some water. Yes, afternoon, Aaron.
First of all, thank you for inviting us to your first ever press conference since being appointed on March 16th this year. I have a couple of questions on the instant matter.
Thank you.
A couple of questions unrelated.
I will very unlikely to take any questions on any unrelated matters. Let me put that on the record right away. And I have to return to Parliament because Parliament is sitting and I have to be at committee stage this afternoon to advise on legislation that is being reviewed currently.
Well, I will first ask on the public's behalf, and you can respond as you see it. In relation to the issues regarding the Office of the Procurement Regulator, there have been 3 amendments, as the document says, and these consultations appear to be coming after the Act has been in Parliament and debated upon. Is this putting the cart before the horse? Are we now going to ask for consultations when there is an opportunity to debate the matter in Parliament?
Well, no, the consultations that I am recommending have to take place now with the Act having been passed into law are consultations to ascertain how ready are we to implement the law. And therefore, it is now that we have the shape of the law before us and we recognize what is required, that I am of the view, on the basis of what the judiciary has said to me, that we need to reach out to public bodies and agencies to audit their state of preparation so that when the Act is proclaimed, the country continues to function. So it's not the cart before the horse.
My follow-up question is that the Office of Procurement Regulator has been functioning for some time now. They've hired investigators, they've hired attorneys, they've hired accountants, they've hired a lot of administrative staff. They're being paid a significant amount of taxpayers' money in salaries. What work have they been doing all this time?
You'll have to ask the procurement regulator that, Darren.
But
I can't speak, and I don't purport at all to be able to stand here today and speak for the procurement regulator. I don't, by anything I say in answer to you or not in answer to you, stand here criticizing him. You will have to address those questions to him.
so, when is it only this year that we realize that institutions that ought to be in a state of readiness is not ready? Is it only this year we found out that?
What I have said, and it is a record in Parliament, in Cabinet, even before I became Attorney General, is that the Prime Minister has been driving the process to ensure that the regulator and the agencies and ministries are ready. So it's not a realization now. It is that when I was asked to begin to look at it, I went to the people who make the difference and I asked hard questions and I have got answers that have caused me to take the position that I have taken now to advise the Cabinet.
Another criticized your predecessor. Was there any work being done on this matter before?
There was work being done. In fact, I have, and I pay compliment to them, I have a very competent team of attorneys in the Office of the Attorney General and Legal Affairs who have been doing work, but at the end of the day, the work that they're doing is legal work to advise on state of preparation, not the actual physical readiness to get all of the different ministries and agencies. And one has to appreciate, and it might be interesting for me to just read, to address that question that you've just put. It might be interesting for me to just read one of the comments that the judiciary made in relation to their concerns. Under the rubric on page 2 of 29, in the comments, under the rubric, the scope of the Act, they say the Act applies to all levels of procurement and makes no distinction in process or liability under the Act between the purchase of a dustbin and the construction of an overpass. All procurement is subject to the provisions of the Act unless specifically exempted by the Minister. The Act applies to a vast body of persons and bodies at all levels of activity. Caught by this legislation are public bodies, private bodies using public funds, and private-public partnership arrangements. There are three definitions which together illustrate the number and level of bodies and persons which are required to conduct all of its procurement in this way and to report in detail extensively. And then they spell that out over 29 pages to demonstrate the scope, the breadth, the width of the Act and the extent to which there is a preparatory undertaking that has not been sufficiently undertaken at the levels of these bodies to make them ready for the procurement. For the proclamation, sorry.
Just a couple more questions on the OPR. As you said, you give an estimate of when you'll be ready. You say as soon as. But
I said in the shortest possible time.
But that is lawyer's language to say we don't know.
I'm a lawyer, Darren.
The state of unreadiness of the judiciary seems they don't even have any staff. The state of unreadiness in the different departments, public departments, doesn't seem that they were even thinking about getting ready.
I'm not going to speak for any of those departments. As I say, I have begun a process of consultation. I have spoken, I have consulted with two organizations, the procurement regulator and the judiciary. I have not yet had the opportunity to speak with others, and what I have committed to today in Parliament is to begin that process. Let's talk in a month's time. I may be better able to answer those questions.
As you know, this piece of legislation, as well as campaign finance reform, were two platform promises made by the I.A.N. when assuming office. And we are in 2022, 7 years thereafter, and we are still saying we are not ready.
Well, I would put it this way, and to the extent that there were campaign promises made, I accept that. Of course, as you appreciate, I've only just come to the office and beginning to familiarize myself with the processes that are involved in being in the political world. But what I do know, and I have said, and I go on record to repeat it, is that the cabinet has been driven and has continued to be driven by the Prime Minister. Whilst he's been abroad, he has sent me messages to say, can you please let me know what's going on with the procurement legislation? He has been driving it from the time I've arrived, and I'm able to say on the records that I've looked at, he's been driving it before I arrived, and therefore there has been no lethargy or disinterest in moving the proclamation forward. The question is, can we do it without bringing our public bodies and agencies to a grinding halt? And that is the big concern now, having received only one comment that I have received in 29 pages from the judiciary.
So I'll just ask this question and up to you to respond. I'm glad you said that you've been in contact with the Prime Minister as he's abroad. You came back into the country after your holiday on May 1st, correct?
That's correct, yeah.
Since your return, there has been much press reports. You have issued 3 statements in relation to an issue which arose out of a Miami court hearing, correct?
Before we get to that, may I ask if anybody else in the room wants to ask me any questions concerning the subject that we came here to discuss, Darren, if you don't mind? Does anyone else want to talk about public procurement and the statement which I made in Parliament today? No one else wants to talk about the statement I made in Parliament today? Okay. So, in answer to the question, what's the question, Dan? Well, yes, so I asked, what's your question?
So, in your last press statement issued on Monday, you made a startling statement which said, I'll paraphrase, you said that you wanted to correct an anomaly in your first affidavit which you filed in relation to a motion filed by the defendant in the Piaco Airport case in Miami, which sought to strike you out as the main litigant or the representative of the Republic of Trinidad and Tobago, as well as the law firm, on the basis of a potential conflict of interest. You said in that the third statement that you were awaiting a call, you were awaiting a message from the client representative, Attorney General Acting Parasalarawi, to call you in your hotel room as you sat there, near your phone, waiting to submit an additional affidavit to correct what you, on reflection, realized was not a totally accurate affidavit that you filed in the first instance. What efforts did you make, if any, to contact Mr. Al-Rabi or seek follow-up to submit an amended affidavit to correct the court's record? As an attorney, you will realize that as a fundamental rule, that once you realize a court is being misled, it is upon your interest to correct the record as soon as you can.
May I make 2 comments on that series of questions, Darren? One is, I don't intend to make any comments beyond what I said in the statement that was published on Monday of this week, and I'm not going to change my mind on that. The second comment that I make is that you've asked so many questions rolled up into one long, rambling series of questions that if even I was inclined to answer them, I wouldn't know where to begin.
I could break it down if you like.
I'm not inviting you to. I'm not making any comments. I've said what I had to say in my statement. I assume everybody has read the statement. If people have not read it, I invite you to read it.
So what would you say to the growing chorus of calls to you as the titular head of the bar to step down on the basis of a potential breach of the Code of the Legal Profession Act and the ethics which govern the legal profession, where a lawyer ought to be forthright, truthful, honest with the court?
What I will say to that, Darren, is to repeat what I have said before. I have nothing further to say beyond what I said in my statement that was published on Monday. And ladies and gentlemen, if you all have no further questions on public procurement, then I think this media conference is over.
I have a question, sir. Good afternoon, John Ramsad from Guardian Media. Mr. Armour, you said twice already that you're not going to address that issue. Can you tell us why you're not addressing that issue?
Because I'm not.
Do you think that that statement is sufficient to the members of the legal fraternity and the public at large who have been waiting to hear your pronouncement on this issue?
I have already pronounced on the issue, Ms. Rampasad. I have said as much as I am prepared to say. I have said, and I am not going to repeat beyond those things that are already stated by me, that there are impending judicial proceedings. I do not intend, beyond what I have said, in very restricted terms, to make any comment on anything that has the potential to impact on the proceedings that are taking place in Miami. I do not intend, and I will say only this, I do not intend to give anyone another Section 34 opportunity to derail the trials that are taking place in Miami for another 10 years. Thank you very much. If you all have nothing further to ask on public procurement, I am quite happy to. Yes, sir.
What do you have to say about the false victim exam?
I have nothing further to say, sir. Thank you all very much. Good evening.